Good evening. It's Thursday, July 20, no, it's Tuesday, I'm sorry, summer vacation. It's Tuesday, July 24th. It's 6:02 p.m. and I'd like to call the Policy Committee meeting of the Board of Education to order. We're here in the Nashua North Boardroom. Present this evening are Board President Dottie Oden, Assistant Superintendent Donna Fitzpatrick, myself, Heather Raymond. We have Susan Porter, we have Ray Guarino, we have Doris Hohensee, and on the phone we have William Mosier. And my understanding is Mr. Mosier is participating by phone while he continues to see to his medical needs. Mr. Mosier, are you still there?
I am here.
Oh, good, I didn't lose you. Yay.
And you're by yourself, right, Mr. Mosher?
Yes, I am.
Thank you, sir.
Thank you, Mr. Guarino. I always forget. Okay, so we have a quorum. So I just want to dive right in. We have quite a lot of material this evening, as usual. So the first items on the agenda, I'm actually going to ask that we kind of talk about GBK, KEB, and 1120 all together because they're related. And then we can go back and look at them separately. So GBK we had worked on last month. We sent to the main board for some wordsmithing because we wanted to make sure that we were having an appropriate outlet for our unaffiliated people. And during our main board meeting, Mrs. Van Twyver was able to take our very cumbersome paragraph and make it a lovely one sentence. And I just thought that I really appreciated it, so we changed it. KEB is along the same line on the complaints, and this one is regarding public complaints about school personnel, and it outlines how a person would go about making a complaint. And basically it outlines that the school administration should be studying this and then bringing it to the board if there's not a resolution. However, we had a policy in place, and we've had it since 2003, policy 1220. And 1220 specifically allows anyone to apply to the board in writing for a hearing if they disagree with a decision by the superintendent, for example. And I thought it was really important that we not lose that policy. So I brought the three of these to town council to ask his advice on legally how can we keep what we have because it's important, but also bring ourselves in line with what all of the other districts in the state have. And his suggestion was to not combine the policies, but instead keep 1220 on its own and give it its own number, which under the new lettering system would be KEBR. So that's why they're separate, but they're all related. Does that make sense? So why don't we start with GBK, and then we'll look at the two proposals for the KEBs, okay? Did anyone want to make a motion? Does anyone want to have discussion before motions? I'm open to either.
Well, I'll make the motion to accept GBK as presented.
Okay,
I second.
thank you. Any discussion on your motion, Mr. Mosier?
Nope.
Okay, would anyone else have a comment? Mr. Guarino?
Yeah, I think we've been over this before. We brought it to the main board, and then it came back again. So I think we're pretty satisfied with what's in it.
All right,
So.
I agree.
I agree.
So let's take a vote. Should we accept it and move it on to the board?
So moved?
Okay, on the motion, Mr. Mosher,
Yes.
Mr. Guarino votes yes. Ms. Raymond?
Yes.
The motion carries 3-0.
Wonderful. Okay. And then KEB, public complaints about school personnel. Again, I'm welcome to entertain a motion at this point or to have some discussion prior to or after a motion.
Okay, I got I've read this policy, and I tried to find something that I could pick at, and I could not. So I would take this and again accept KEB as presented to pass.
Thank you. I'll
I'm sorry.
Oh, go right ahead, Mr.
I
Guarino.
second the motion.
Okay. Mr. Moser, did you have any other thing that you would like to speak to on your motion?
The only thing I'm thinking about is KEBR.
Okay.
And why can't KEBR be tacked on with KEB? So that would be passed all at once.
I think when I met with Attorney Bolton, KEBR, the proposal to change 1220 to KEBR is more of a procedural, and in our other policies, and as I looked at all the other policies, things that are more procedures were ours, whereas policies were just the letters together. He also felt that it was important to have this one standalone for.
Okay, I'll go along with that.
Okay.
I bow to his knowledge. Let's go then with KEB.
Okay. And Ms. Hohensee, I think I saw your hand.
Yes, thank you. I'm just concerned, this is a new policy, and I think there might be exceptions. You're talking about a public complaint about school personnel, and you're giving it to the administration, and they're going to go through the building hierarchy, and then if there's a complaint about a higher level, like at the central office, we wouldn't go through this process. I mean, there are exceptions. That's my concern. I know this is like standard we do most of the time, maybe 95% of the time, but what about those extraneous cases?
So I guess I would say that if there were a complaint in central office at any level other than the superintendent, it would go to that person's direct supervisor and then up the chain. So for hypothetically, if someone had a problem about Mrs. Fitzpatrick, and I'm not saying that anyone does, but should they, then the appropriate person to investigate that would be her direct supervisor, which would be the superintendent. And then if they weren't satisfied, then it would come to the board. Or if the superintendent felt that it rose to the level of needing board involvement, he would then bring it to the board. If it were, for example, a complaint about the superintendent, that is why we wanted to maintain that policy 1220, even though I couldn't find any other districts that had anything like it. But I very much felt it was important, and Attorney Bolton concurred, that we have a way that if someone either didn't agree with the superintendent or had a complaint about the superintendent, that there was a way to ask for a hearing in front of the board. Mm-hmm. So my hope is that these don't prevent people from having their grievance heard, their issues heard. But I do think that if someone has a problem in the public, writing to an individual board member, I don't believe it is our responsibility to personally investigate that stuff. We should refer it to the supervisor of, the person who the complaint is about.
Okay, can I follow up?
Sure.
Because I think we've had an instance, that we've had instances over the past year where we didn't follow this direct hierarchy. We had another method. And I'm just saying that that's not listed here. But the hearings, I think, is critically important. I think there's a lot of policies that say if a parent is grieved with a decision, that they can go through the hearing process to the board. And if they don't like that, there's another hearing process at the state level for many issues. So I understand that's a standalone, and I'm surprised that other districts don't have this. I'm pretty sure that they would. I don't know what numbering they have. I'm just worried about an exception to KEB. But then again, we just override a policy. It's better to have it in, but if something doesn't comport to what this is, we as a board can overrule a policy that we set.
Do you have an example, even a hypothetical, of what you feel wouldn't be covered?
Well, I think over the course of the year, we've gone into non-public to discuss some things like that. I'm not going to discuss anything like that here.
Okay. All right. Any other discussion? Okay, then I think we're ready to vote on Mr. Mosher's motion to accept it.
Okay, on the motion to accept KEB as presented, Mr. Mosher,
Yes.
Mr. Guarino votes yes. Ms. Raymond?
Yes.
Motion carries 3-0.
And I have to apologize. Mr. Kaufman was unable to come, but he had sent me an email, and I forgot, and I failed to read his comments on the first two, and I want to make sure that I have his comments for the record, and so I need to apologize to him. I will send him an email later. But regarding GBK, he had some commentary about wanting after agreement. He wanted that the unaffiliated handbook procedure for grievances shall be followed, and he would like the unaffiliated handbook to be placed on the website. He was wanting to make sure that we have a distinction between union and non-union, which is what it says. Collective bargaining agreements would be union, and then unaffiliated would be non-union employees. So I think we've addressed that. And in KEB, he had some questions about what if the complaint is about the superintendent and his assistant superintendents, which I think we just discussed. So hopefully we have covered that. Okay. And so KEB, moving on to 1220.
We'd like to rescind that, right?
Well, I'd like to change the label from 1220 to KEBR before we rescind it so that it doesn't disappear.
Okay, so moved.
Move to change, what is it called, the title or the? What did you just-
Designation.
Designation, okay.
Good word. From 1220 to KEBR. To
11:20.
1120?
See, I don't know which is correct.
Hold on, I have it.
Okay. Because this says 11:20 and this says 12:20. And I think it's 12:20, but I'm not sure.
Okay, let me just double check. I have the old one. 1220. So note that on the agenda it says 1120, but that is a typo. It is 1220, which is correct on our sheets. Okay, so Mr. Mosher has made a motion that we change the designation from 1220 to KEB-R.
I second it.
Okay. Any further discussion on this? Okay, seeing none, I want to make sure that I have Mr. Kaufman's notes that he sent me. Mr. Kaufman has suggested that the policy is rewritten to reflect its procedural intent and sequential order of communications. He would like to ask that we, instead of applying in writing, I think, that we request that the person request a meeting with the board and state their desired outcome. Then the board votes to hear the request for the hearing, and then the board would set the date, 5 to 14 dates out. And then the person requesting the meeting shall be given the opportunity to address the board and respond to any questions from the board. He also would like to have it noted that the person requesting the meeting is allowed to invite witnesses to speak on their behalf and may bring counsel at their own expense if they feel it is necessary. So, did anyone have any response or thoughts about Mr. Kaufman's information that he sent me? Mrs. Fitzpatrick?
I was just going to say, the way the hearing policy is written, it doesn't prohibit somebody from bringing representation or witnesses. It doesn't say they can't.
Mm-hmm.
So
And I mean, I think the language in here regarding persons at hearing shall not comment on any matters or address the board, I think that refers to like observers, not necessarily not the person bringing the hearing. Did anyone else have any? Mr. Gordon?
I think that that's perfectly clear. That little sentence there does apply to people that are not involved in the hearing, but are not able to give their opinion, because otherwise you'd have people that would be interrupting, and they have no business to interrupt.
Okay, thank you, Mr. Roder. Mr. Guarino?
Thank you, Madam Chair. So we have had hearings in the past based on this policy, is that correct?
I don't know.
Because it's 12/20 and it's in effect, and our past hearings have been based on this policy? Okay, so it seems to me that we have a process already there, so I think it's fine the way the way we've conducted our hearings are fine, and I think we have had people bring witnesses and et cetera. So I think that's all inherent.
that's true.
Yeah, inherent in the policy.
So, Mrs. Oden, can I pick your memory? I'm aware of grievances. Has the board had individuals in recent history request a hearing that was not a grievance?
I don't remember any. I don't remember any. We have had grievance hearings, but I think that might be a little bit different. Do you remember?
Earlier in the fall, we did have a hearing regarding a student issue.
Oh, okay, yes.
With
Yep.
witnesses,
It
et
was-
cetera?
Yes.
Yes,
Okay.
I'm sorry.
So I assume that would have fallen under this policy?
Yes.
Okay. Good. Oh, that makes me feel better.
So it appears that it's adequate, the
Okay.
way it is, yeah.
Well, I mean, it's been there for 15 years, but I want to be certain that people are aware that they have this right and that, that they can request a hearing and, so.
I could go back at least 12 years and say that I've never had any problem with it.
Okay. Thank you, Mr. Moser. Ms. Hohensee, did I see your hand?
Yes, thank you. I think Mr. Kaufman, his attempt to be clear and add things for clarity are useful, because I know some people that are coming to hearings, they don't always know what's expected of them, and I think it's helpful to them to see it all broken down. And I think in that sense, what he's introducing is very good. When it says persons in the last sentence, that's the same as persons in the first sentence. So if you're coming for a hearing, you don't just get to talk until you're invited to do so. But it doesn't say also in here that it could be public or non-public. These are due process hearings. It could be a grievance hearing from the union. It could be a personal issue. It could be a discipline issue for a student. Any number of reasons that we'd have a due process hearing.
The attorneys will always make sure that it's noted that they can request the hearing to be non-public or public.
If I may follow up on that? Yes, they do. But what I'm saying is Mr. Kaufman's presenting a lot of the different options. So for the inexperienced person that's coming to have a hearing, they're not as well equipped as the lawyer that's representing the district or the board to know what to expect to prepare properly. It's a courtesy to put it out there. I think in that sense it's good as long as we agree upon the terms. But I mean, just noting in here that it could be public or not public might be helpful to parents to know before they walk into one, what the expectation is, because it's nerve-wracking, and this, having information is power. They can plan and prepare and get themselves ready, knowing that they can bring witnesses ahead of time so they don't have to get here and say, hey, I didn't bring a witness. It would have been to my best interest to do so. I think what he's presenting is good in that sense, because I like it open and transparent.
Well, that's what they have attorneys for.
Thank you, Mr. Mosher. I happen to agree that people should, I don't like the idea of someone showing up and not knowing what they need to know in order to proceed. It makes me very uncomfortable. And I certainly dislike the idea of inefficiency of someone coming here and having witnesses and not having brought them because they didn't know they could. And I'm curious about historically, when someone has asked for a hearing under this policy, does administration, when we schedule it, like what are the actual steps that occur? Someone writes to us, they ask for a hearing, we vote on it, we say yes, and then someone must contact them to say, here's the date it is scheduled. And then at that time, I assume it's like Tara or Rosie or whoever
Right.
schedules it.
Correct.
At that time, they would say, here's what you need to know for a hearing?
That's a great question, and my assumption would be yes, but I cannot say yes for sure.
Well, from experience, the two people that are involved, their representative and the superintendent, because they have to have the dates and times and all of the various details, forward in the information that these people will get, whether it's for student discipline or whether it's a workplace or whatever the case may be. So they do not come into the hearing unprepared. That would be ridiculous to have that happen. They walk in and say, what happens next? No, that doesn't happen. That's why we have two attorneys, and we have the superintendent, and we have the members of the board that will be there. So the information is shared, and they are prepared to either answer questions or nod their head yes or no.
Mr. Guarino?
Thank you, Madam Chair. I agree with Mr. Mosher. I think we ought to, I think this policy has worked in the past, and I think what's important is to keep it pretty simple. If a person looking for a hearing to look at this policy, I think they could focus on stating the reason for their request and the action desired on it. So anybody asking for a hearing should focus on that. And as Mr. Moshe said, they would, there's other ways of them getting information as to what goes on, for the hearing. They don't come in unprepared. So I think that's what we should focus on, and not convolute it with more, adding more stuff. Keep it kind of simple, and I think it's adequate the way it is. It's worked in the past, so.
I mean, to be honest, I'm not opposed to Mr. Kaufman's, I think the first half of it regarding requesting a meeting, blah, blah, it's in there. But he has two lines at the end that says the person requesting the meeting shall be given the opportunity to address the board and respond to any questions from the board. I don't have any opposition to having that in there, except that we have to vote as a board if we're going to have the hearing. And I would say if we vote not to have the hearing, like say the board feels like the hearing, hypothetically, say we feel it's a frivolous matter or it doesn't rise to the board, it needs to be handled at a lower level. I don't want to have something in there that says that they have a right to address this if we've just voted that they don't. But the last line in his email says, the person requesting the meeting may invite witnesses to speak on their behalf and may bring counsel at their own expense. I kind of like that line, that we perhaps ought to add persons at hearings. And I'm not sure about, and I almost think that the person, if a hearing is granted, the person who has requested the hearing may bring counsel. I don't think that's a bad thing to write in the policy. So I turned myself off. Ms. Porter?
Thank you. I think it wouldn't be a bad idea to clarify, because you do have persons desiring and persons at hearings. It's true, it's the same word, and I don't think it would hurt to say, to clarify the person desiring the hearing as different from observers or people in the
No,
audience.
this is the same one.
It's the same one?
I thought so at first when you said that, but excuse me for
No, go ahead.
interrupting.
No, please go ahead, Ms. Hohensee.
I think it says persons at hearing, meaning the person requesting it, shall not comment on matters before the board or address the board unless they are invited to
The
do so.
same person.
I think what they're saying is there's a process, and they will be invited to talk.
Okay.
This is a good place to say that they will be able to
Okay.
if the hearing is granted. But we also should include that it can be public or private. Not all of the grievances or hearings that I've heard have come with counsel. Sometimes they're at a disadvantage, sometimes it doesn't matter. So sometimes being helpful saves us time when they come here, because then they know what to expect and they're in the right frame of mind.
So nobody explains to, so between, I guess, between when you're accepted, there maybe could be something explaining it, and I assume that once we're here, the attorney would explain the rules of the, I mean, don't you do that just as an opening statement? This is what's happening. I assume that happens.
Yes, you're assuming correctly.
Okay.
Okay.
Because what you had as a hearing, you do have the council, which is the city's council, and then you have your own, which is at your own expense. And we have this has worked fine over the past years, and I don't see any reason to add to it or change it in any way, because why try to gild the lily? You've got a good thing going there. Leave it alone.
Thank you, Mr. Mosher. Ms. Hohensee had her hand up, and then you, Mr. Guarino.
I just think that they do come at a disadvantage because they're not familiar with the process. A lawyer is. There's a good number that come without an attorney. Anything that we can do to facilitate the process, to make them understand and feel comfortable walking in, is good. If they don't find out they could bring a witness till they land here, there's no time to go get a witness. So, and we can't assume that somebody in staff will have talked to them and briefed them unless there's a form that we know. We can't assume that they'll get all that information. I know they have come here confused, and then they are straightened out, but they didn't have the advantage of knowing in advance like our side does. And I don't like to see that one side is at an advantage over the other.
Well, you're correct in thinking about that, but again, this is not a criminal thing. This is a thing which is has to do with the school district. And again, we do not have a lot of this that goes on. This is only a once in a while. If we have twice a year, that's a lot. So we do not have this going on all the time. And for people that think they come in like you, if you think that they come in here not knowing what's going on, that's foolishness, because they are well advised of their rights and privileges before attending the meeting. So they come in here, and they're not coming in blind. They're coming in well informed. They know what to expect. They know what the charges are that may be presented, and they are informed well in advance that if there are witnesses that they should bring, so be it. They advise them and have them come in and show up. And after the years that they've been through this, there's no reason to add any other language to it.
Mr. Guarino?
Yeah. Thank you, Madam Chair. I don't want to encourage people to go get lawyers. If we put in there that, that they should get lawyers, and some people come in with lawyers, some people don't. Sometimes it rises to that level, sometimes it doesn't. So it's all different. So I think better off just leaving it out.
Okay. I actually have I'm of the opposite mind. I'm inclined to make an amendment, adding a line right at the end, just saying persons granted a hearing may invite witnesses to speak on their behalf and may bring counsel at their own expense.
Why add it at the end when they already advised of that before they even start?
Oh, I mean, at the end of the policy, I just want to add a line. Yeah, I'd like the whole, I'm just going to read the whole policy, the way I would amend it. And I would say persons desiring a hearing before the school board must apply in writing to the board for a hearing at least 5 days prior to the scheduled meeting, that would be the next school board meeting, stating definitely and clearly the reason for the request and the action desired on it. No hearing shall be granted without a vote of the board. Persons at hearings shall not comment on any matters before the board, nor address the board unless they are invited to do so. And I would add the next line, persons granted a hearing may invite witnesses to speak on their behalf and may bring counsel at their own expense.
You want to amend that?
I would like to amend it. So I move to
Well,
amend.
as you stated it, I would have no objection to it.
So I move to amend it to add that last line. Persons granted a hearing may invite witnesses to speak on their behalf and may bring counsel at their own expense. Should we say to the hearing? No, I don't think so.
That's
I
understandable.
think it's redundant.
Okay, can we move it now as amended to the board?
As soon as I write it down, and bring counsel, what was the last part?
At their own expense. Oh, I'm sorry, I have it written down.
At their own expense. Okay.
Mrs. Oden?
I guess what concerns me, they apply at least 5 days before a board meeting. If they come to the board, they bring an attorney and witnesses, and we vote not to hear their case, they have expended this money for no reason.
I agree with that concern.
So I think, just my opinion, I think it's worked for 15 years, and I think we should leave it as is.
Thank you. I think my intention, and I'm going to speak for Mr. Kaufman, but I might be wrong, but my interpretation of his intention was that they would have the right to bring their counsel and witness to the hearing if it is granted. So not to the board meeting where we are discussing if we're going to grant it. But perhaps the language change was unclear. Ms. Hohensee, you had your hand.
That was my understanding, that the board gets to vote, but not necessarily the hearing is that day. Then they schedule one.
We schedule it.
It can be a two-step process, the paragraph that's already in policy. So you wouldn't have to bring an attorney while the board voted. You'd have to bring it to the hearing, which is a later date. We could make that clear if there's any confusion.
I think that's clear enough as it is.
And any further discussion? Does anyone else have an objection to adding that line?
I don't, I object to the amendment.
Okay. Do you have any other discussion you'd like us to have before we vote? Or alternative language? No? Well, let's call it then. So as I understand it, the vote would be on my amendment to add that line.
Okay, on the amendment, do you want the amendment yes or no, Mr. Mosher?
Yes.
Okay. Ms. Raymond?
Yes.
Mr. Guarino votes no. The amendment passes 2-1.
Okay, so we will send that one. Oh, so now we need to vote to see if we will send it on to the full board as amended. And so Mr. Mosher had already made that motion, so now we're back to voting on that.
Okay, on the motion to change the designation of 1220 to KEBR and amend it with that line, persons granted a hearing may invite witnesses to speak on their behalf and bring counsel at their own expense. Mr. Mosher?
Yes.
Ms. Raymond?
Yes.
Mr. Guarino votes yes. Motion carries 3-0.
Okay, thank you. All right, moving on is policy 1230, complaints, which now that we have adopted 3 new complaint policies, really 4 if you count KEB/R, policy 1230 is now redundant. So we had approved a policy, I forget what number, at the last full board meeting, and then we have now sent 2.5 up to the board for approval, and they incorporate all of the items 1, 2, 3 on this policy 1230. So I propose that we rescind 1230 so that we're not having redundancies. So, I'm looking for a motion or,
So moved.
okay, I'll second it.
On the motion to rescind policy 1230, Mr. Mosher?
Yes.
Ms. Raymond?
Yes.
Mr. Guarino votes yes. Motion carries 3-0.
Mrs. Fitzpatrick, can I ask you a procedural question? We had a motion to change 1220 to KEBR. Do we also need a motion to rescind 1220?
You're rescinding the number.
To rescind the number? Okay. Then I'm going to go ahead and make the motion myself to rescind the number 1220 as we now have KEBR to replace it.
I'll second. On the motion to rescind the number 1220, Mr. Mosher?
Yes.
Ms. Raymond?
Yes.
Mr. Guarino votes yes. Motion carries 3-0.
Okay. Thank you, Mr. Guarino. Okay, and now we have some legislative changes and updates that go along with those. And I have to thank Mrs. Hohensee for bringing these to our attention. So the first one is policy ILBAS, which is the statewide assessment policy. In your packets, you'll see that I have included a copy of the change to the law, and I've highlighted the relevant parts and how it changed. And then when I was researching this, I discovered that we were actually out of compliance with the New Hampshire Department of Ed regarding exemptions. The state, oh gosh, all the way back in 2014, had a technical advisory to let all of the districts know what were acceptable exemptions from statewide assessments. And so I have also updated the policy to reflect the language in the technical advisory from the Department of Ed. So there's 2 big changes. The first, as you're reading down the policy, is to change the exemptions to match what is listed in this Department of Ed technical advisory from 2014, which is the most recent information from them regarding exemptions. And the second change is to add a heading results and then add the specific language from the law regarding not having the statewide assessment results be a part of a student's transcript unless the legal guardian or the student wants that to happen. So I see Mrs. Hohensee has her hand up. Did you want to discuss before motions?
It's up to you, but I do have things to discuss.
I'm indifferent. I feel like committee meetings are more like, working sessions, so I'm happy to discuss unless one of the members of the committee wanted to make a motion.
Not yet.
Okay, then please go forward.
Thank you. And I appreciate the results being put in. That's complying with the new state law. I have a big problem with the exemptions section. I think if you looked back at our minutes from 2015, this district, along with Manchester, put in a resolution to notify parents and allow them to opt out. At that point, we had a legal firm that attended both those meetings and offered free pro bono services to any parent who was not allowed to opt out their children in violation of their constitutional rights. So that wasn't necessary. The policy was passed. There was a lot of commotion over Smarter Balance at that time. The following year, in 2016, the board again passed a resolution to allow it to happen. And then when we did the policy that you're changing, we made it very clear that parents could do that in 2017. So there have been at least 3 times that I've been here to discuss that. 2015 was before I was elected to the board. This is not the most recent. I've got 2 handouts. I'd only have 2 copies. I'll pass what I've got, and then I'll explain. One is the Department of Education Technical Assistance Advisory from January 13, 2015. And the relevant parts of that are on the back and highlighted in yellow. I apologize that you'll have to share. I didn't know how many people are going to come. It says, the relevant part was, there are no laws in the state of New Hampshire or rules at the department that would penalize a student for not participating in the statewide assessment. Additionally, the same is true of a parent determined that they would not allow their child to participate. So there is no punishment. They're recognizing, along with this other sheet in the front, you can see some gray areas that was highlighted previously. I couldn't find a clean copy. But it recognizes that every year, for various reasons, parent refusals are but a few of the issues that are not entirely within the district's control. I think there was somewhere around 500 parent refusals before the Smarter Balance came in. Afterwards, the refusal rate went quite a bit higher. And I know the test has changed. I know we've gone from Smarter Balance to SATs, and there have been a lot of switches around. But I do not think this is unlawful, putting this in and telling parents that they can't, because they can.
Well, I will say that I cleared this with Attorney Bolton because I wanted to make sure that we are complying with the law. It is not unlawful for us to say the state recognizes 5 circumstances for exemption. That's allowed for us to state in our policy. These are the reasons why the state allows an exemption. Now, if parents want to then contact the superintendent and ask for an exemption otherwise, that I think is between the parent and the superintendent to decide if they want to allow it. But I don't see where we would be breaking the law to list what the state has said the exemptions are. Please go ahead, Mrs.
Thank you. And I understand that's been the protocol. When we had this previous commissioner, there was a lot more hostility towards allowing parents to exercise their rights. Recently, the legislature passed a bill, 1744, which is effective today. This bill authorizes a parent to exempt his or her child from participating in statewide assessment program. Prior to this, parents had to opt out. And there was a big thing. When you tried to exempt your child, you were shot down. When you opted them out, you were allowed. So you had to have the secret handshake. Well, that's not the case anymore. Parents may exempt their child. It's their constitutional right, and now there's a state law recognizing that constitutional right.
So my question, I guess, is RSA 193C6 is what's mentioned in your addendum. And I don't see anything in RSA 193C6 that says parents have the right to exempt their child for any reason. All I see is this addendum saying there's no law penalizing it for not participating, but I don't see anything in the actual law that says that, I mean, the law says all public school students shall participate unless they are exempted. And it says that, exemptions can only be approved. Here, exemption RSA 21N1, exemptions can only be approved through the director, and here are the following exemptions. The addendum just says that there's no penalty if you were exempted. So I guess I'm still not seeing the conflict, but I'm happy to take the information that you have and double check it with the attorney, because I certainly want to make sure that whatever we do doesn't violate a law. I just don't see that. Does anyone else have a comment? Mr. Mosier, anything?
I'm thinking.
It's difficult, I know, because you don't have this in front of us. Do you mind if I read the addendum?
I have a follow-up.
Yeah, go ahead.
If I could respond. When I sent you these three bills that had passed last year, this one hadn't passed. This one passed this year. I didn't see any need to send it to you because we already had it in policy. So what you're doing is reversing the policy. Now there's a reason to give you this new bill, which I have on my screen. I'm happy to pass down my laptop if you'd like to look at it. It went into effect today. So it wouldn't be on the website because it went into effect.
Okay, well, that would be why I wouldn't be aware of it. So I would suggest at this point that we table this so that we can look at the new law and discuss it with the attorney, because I don't want to make changes that are on a law that takes effect today that I wasn't aware existed. So
That might be a good thing.
okay.
Because I have a sheet here, and it gives 5 reasons for being exempted from the statewide assessments.
Okay. And I'm sorry, what's the new law today, Mrs. Hornsey?
It's 1744 House Bill, an act authorizing a parent to exempt his or her child from participating in statewide assessment program. There's no penalty for the parent. There's no penalty for the district. This is something that was in progress for many years. It got passed. It never got signed. This year it got signed. I would recommend that we pass the second change that you put in here, because we know that that one's correct, and just table the first part of it until you can review it.
Thank you, Mrs. Hornsey. Mr. Guarino.
Thank you, Madam Chair. I don't think that this policy that we have in front of us is in conflict with 1744. What she just described was that a parent can exempt their child, and this lists exemptions. So this is saying that this policy is saying that you can exempt students, and that what she just read is conforming. It doesn't say you can't exempt them. This policy says you can exempt them. So I don't see where the conflict is.
Oh, thank you, Mr. Guarino. I appreciate that. I'm going to make a motion that we table this until I can get that HB 1744 and sit down with counsel and get a legal opinion, because I do not want to pass something that is in conflict with the state law. I just feel very uncomfortable with the idea of doing that. If I could, I'd like to move to table this until I speak with Attorney Bolton or Clausen, whoever is available to speak with me.
I'll second it.
Okay. Yeah, we do. I'm just giving Mr. Garno a chance to write it down because he's kindly taking notes for me.
Okay, on the motion, Mr. Mosher,
Yes.
Ms. Raymond,
Yes.
Mr. Guarino votes no. The motion carries 2-1.
Okay, thank you. All right, I'm just making myself a note so I remember to, Mrs. Hohensee, may I keep these to bring with me?
Definitely, yes.
Thank
And if
you.
you look up on the state website, you'll be able to find that bill 1744 before you go to talk to council.
Yeah, I'd like to print it out and bring it with me so
It's
that,
on my screen if you want to look at it after the meeting. But what you can't do, you can't act in the color of law by saying, these are the only 5 exemptions, and it doesn't list the parental exception. So you're saying if you have a medical emergency, a severe emotional distress, death in the family, and 2 other things. So you're giving a bar that's this high to parents and saying, that's the only way you'll get out. Whereas this law says they may make the individual decision. It's not listed in there. So if you put this in, this will be in direct violation of the law.
as I said, Mrs. Hohensee, I very much want to make sure that we are in compliance, which is why I would like to have his advice before we move forward. It's not my intention to break the law.
No, I have a quick question.
Go ahead, Mr. Guarino.
I'm not sure, you said that this law, this policy doesn't cover something that's in there, but I'm not sure exactly what you're talking about. They can just not allow their kids to take it for no reason, is that it? Or, because I'm not sure, you keep saying there's something in there, in here that doesn't cover what's over there.
There's the updated statute.
Right.
It gives parents discretion for exempting their child. They don't have to prove to the district the reason why. They just have to exercise that right. This has been an ongoing battle in the state,
Right.
not just in Nashua,
Right.
since the Smarter Balance came through.
Right, so I think the problem that I'm having is the term exemption, so maybe it's just refusal rather than exemption, because these are exemptions, and that says that the parents have the right. I'm not trying to belabor that, I'm sorry for belaboring it, I'm
No,
not
that's
trying to
all right,
argue.
and that's
I'm
good
just
to
trying to get the
understand.
terminology correct, because that must be then outright refusal for no reason, for no exemptions.
No.
For no
If I may continue.
Sure.
Parents had to use the correct term before. If you called your district and you said, I want to exempt my child, they were told, no, you don't fit an exemption. If they were told they wanted to refuse or opt out, they would be listened to. So now this law gives them the right to exempt. So in other words, there's no secret handshake. You don't have to have the right word. This has been a very controversial issue. And
It's
the
still
bill is-
confusing the way I'm going to have to read it later on. Thank you very much.
So, I mean, it sounds like we all have our own opinions on this, but at the end of the day, I think the law is the law until, unless it changes. So I'd like to have an attorney who knows the law better than us lay people take a look at it and give me some advice. So that's what we'll do. The next item is ILD, which is non-educational questionnaires, surveys, and research. There's the law has been changed. In this case, it's RSA 186.11.9D. And so I have, after meeting with Attorney Bolton, updated our existing policy to include language from the law. And so hopefully we have done this appropriately with the attorney. And basically the applicable changes is that in the past we said parents will be notified 10 days prior. But the law is requesting that we have actual language that states, no student shall be required to volunteer for or submit to a non-academic survey or questionnaire as defined in this paragraph, well, it should be the paragraph before, without written consent of a parent or legal guardian, unless the student is an adult or an emancipated minor. The other change, again, comes directly from that, the language of this law, which is the policy shall not apply to the youth risk behavior survey developed by the Centers for Disease Control and Prevention. Parents and guardians may opt out their child from the youth risk behavior survey, and they must opt out by notifying the district. So for most surveys, like 99% of them, parents need to be notified in writing and consent now, but the youth risk behavior survey by the CDC, parents actually have to opt out of that one, which is a little bit confusing, but that's the way the language does. And I'm noticing one small thing. There's the and sign for disease control and prevention. I'd really like it to just say and instead of the and symbol. It just bothers me. So I'm just going to, if we can have a friendly amendment to do that. So Mrs. Hohensee?
Yes, no, a friendly amendment is great. I think when you pointed out as defined in this paragraph and meaning the previous, could we change that to policy?
Sure.
And then it would suffice.
I think I'm fine with that. Does anyone else? Where is that? So in the red, I copied the language of the law because I wanted to make sure that I got it right. But as I was reading it, and as Mrs. Hohensee just pointed out, it makes a lot more sense if we say policy.
This is ILD.
ILD, yes. So we were just talking about the first red sentence to change the word paragraph to policy. And then in the second red sentence to change the and symbol to the word and. Because it's nicer that way. Okay, does anybody have any other discussion on these changes? So, I mean, I will say my personal opinion is that this is really cumbersome, and I'm concerned about the amount of extra work that it places on our staff, but the law exists, and we have to do what it says. So I'm looking for a motion.
So moved.
Okay, so Mr. Guarino, can you write the motion to say that we will accept it as presented with paragraph in the first red section changed to policy and the and sign changed to the word and, so that it's clear when they do the minutes and the notes that that's the motion. Hopefully that will help Tara a little bit later when she types it up. Thank you. Poor Mr. Guarino, I'm making extra work for him. Yes, Mrs. Hohensee.
You could say as amended in discussion, and Tara would pick it up. She's very clever, but you do need a second for the motion. It would be helpful.
I'll second that.
Okay.
Yes, Mrs. Oden.
I look at this, I think about the board asking, or administration, how students felt about the snow days. I think about the culture and climate survey. We have had students fill that out. And now we're going to have permission for them to do that. That seems absolutely ludicrous to me.
Yeah, again, my personal opinion is that this is an incredibly misguided decision, and it doesn't seem to understand the nature of the day-to-day work that our teachers and staff do. But I'm not in Concord. Nobody asked my opinion when they were discussing and passing this, so it is what it is. And I do feel strongly, and my goal with the policy committee this year has been to go through our policies and try and bring them in line with state law. I just think that's really important, so whether.
And you're right.
So any other discussion? No? Okay. Ray, can you call the roll?
On the motion to accept the policy as amended, Mr. Mosher,
Yes.
Ms. Raymond,
Yes.
Mr. Guarino votes yes. Motion carries 3-0.
Okay. I turned my microphone off. All right, the last item on the agenda tonight is IGE, parental objections to specific course material.
Oh, yeah.
What, Mr. Mosher?
I was disagreeing with it.
You disagree?
No, I said I agree with it.
Oh, you agree with it, okay. Oh, I'm sorry, I have forgotten about my notes from Mr. Kaufman again. For this policy, we have RSA 186.11.9C was passed, and it requires us to provide, to have policies allowing exceptions, and that it requires, which we have, but it requires us to provide parents and legal guardians not less than 2 weeks advance notice of curriculum course material used for instruction of human sexuality and human sexual education, and it has to say how we will notify parents. So that is the language that I pulled it out. I spoke with Attorney Bolton about how to make sure that our policy language reflects the language of the law. I think we did a pretty good job. Just to throw in, so I don't forget Mr. Kaufman's email, he wanted to change on the first line in black, instead of find objectionable, add the word may find objectionable. He also feels like the law doesn't go far enough, and we should not limit it to that one topic. So, Ms. Hohensee.
I think he was confused, and I think it's the placement. I think if he read it without the red text, he would understand that it's all topics. And I think if you move the red text to the bottom, then he'll see that they can object to any course with a wide breadth. And this thing about this new language is a separate issue. And if we put that at the bottom, I don't think it would confuse people reading the text. Because this is giving 2 weeks notice, and shall be provided electronically or in writing. That has nothing to do with opting out of a course. This is opting out of a presentation or some. I think the genesis of this, there was a problem in Manchester. They had an elementary school where they were given some type of sex education, or maybe it was suicide or something, but it was very graphic. The parents weren't notified in advance. The kids went home very distressed. The parents followed up with trying to get some legislation. So that's 2 weeks notice for a one-time event, which is different than the rest of the policy, which is a course material or something. So I think I would pull it at the bottom so it's an appendage and it doesn't confuse the original policy.
Okay. Thank you. I just want to note that I, again, find it ridiculous that we're legislating for an entire state based on one incident in one school or one district. I find that ridiculous. Having said that, I also just think it's ridiculous that you have to have notice in writing to talk about the human body. Having said that, I don't have any strong feelings about where the line should go. I don't agree with you that it is a parent objecting to an entire course. It's a specific material. So again, this would be one presentation, but the next thing would be one presentation as well. It wouldn't be, if you object to the course, you need to take your kid out of the course. Like, why would you have your child sign up for a course if you can't object to the whole semester? You would have to find something else, yes?
Yes, well, I think the idea, course material, you still have a prerequisite to do math or to do English. So they're saying it doesn't override that. But if you don't like this math book, you think you have a better one, or one that you think be more helpful to the child for whatever reason, that's course material. And they still have to meet the requirement. The district still has to agree with the material. That's my understanding of the policy as written before the red was put in.
That's interesting, because I read it as, a particular presentation or perhaps a book that you felt was inappropriate for your child or your situation, not like a piece of literature, not like a math course. Having said that, I leave it up to the principal and the parent to agree to what makes sense for each individual student. I don't think the board has I just don't think it's appropriate for the board to be deciding what's appropriate for each individual student.
Comments.
Go ahead, Mr. Moser.
I'm agreeing with you, because it says in here that there may be course content, not a course, but a course content, which may be objectionable. And that could be something that has to do with biology, the functioning of the different parts of the human body, or it could be on religious type of thing, because you have different people from different parts of the world that may be, situated in one way in their mind that they don't want their children to hear anything about Buddhism or anything about Catholicism or Protestantism. So they want to be exempted or not allowed into those particular classes to hear that kind of thing. From my experience, we have not had a lot of this. Occasionally, you do have a parent who will object and say, well, the sexuality part, I think that's best left up to the parents, which in most cases it would be true. But sometimes the parents themselves are too squeamish to address the child to explain the functions of the body. So having the part in there that says that the parent may approach the principal and say, listen, I don't like the way that this is presented, and I would like for some alternative information to be presented to my child, and let them work it out with the principal. I think that's the right way to do it.
Thank you, Mr. Moser. I would like to point out for the record that we don't actually teach sexual education here in Nashua. So this is not something that is currently applying to us, although I believe there's probably some aspects of a reproductive biology covered in a biology course, but not a sexual.
High school.
Yeah, but not a sexual education
No.
curriculum. So going back to Mrs. Hohensy's point about the location of this line, perhaps if we moved it to after the second black paragraph, would that read more clearly? Because I feel like we should say, like, here are the things that you might find you might find something objectable, here's something we have to notify you of, and then here's what you do about it. Does that make sense?
I would put a parental notification at the bottom, because all the black text is the parent initiating the action. The parent comes to the school with the objection built in, based on what the parent knows about the course. But this red text, the new text, is a notification. The district has a new obligation to notify, and this could be a health course, to notify parents within 2 weeks of when it's being presented. So I would put it separately, because it's a responsibility of the district to notify the parent.
Does anyone else have any thoughts about placements regarding where it is, moving it down one paragraph, or moving it to the end?
Well, I object to moving it, so
You like it where it is, Mr.
I
Mosier?
like it where it is.
Thank you. Mrs. Fitzpatrick?
I just want to agree with your suggestion that if it clarifies it, to move it to the third paragraph and make the third paragraph the second, then that's fine. I disagree with putting it at the very bottom. I think it's out of place at the bottom.
Okay, thank you. Anyone else? I see we are people of strong opinions today. Ms. Hohensee?
It's really not an issue of the content of what we're doing, but if you put it in the middle, then you're talking about the building principal acting on behalf of the district and the parent must mutually agree to an alternative instruction. This new law, there's no alternate instruction. They're just given a book and they go to the library or something else.
I guess I would call that the alternative instruction, because it's not like they get...
It's not clear.
Because if they're going to be in school, unless the parent is saying, I object and I'm going to take them out for the day, if they're going to be in school, the principal needs to find something for them to do during that presentation, correct?
Correct.
See,
So-
the other policy, it stops. If you look at the back page, it goes the first 2 or 3 sentences, and then it stops. This new text is added in. They should have made, section 1 and section 2, but it's completely separate and distinct because the parent's not initiating the change. The district is notifying, and then this policy may apply. But I just wouldn't put it in the middle because to me, it's confusing to understand how it's going to work if you put it in the middle. And I'm just trying for clarity, that's all. I'm not trying, it doesn't push the agenda or one way or the other.
No, and I agree with you. I think this is just a semantics discussion. I think we all agree that the language is clear in the law, and I think sounds like we agree that the language that is being added to the policy is clear and complies with the law. It's just a matter of leaving it where it is, moving it a little bit, or moving it to the bottom. So, Mrs. Oden.
I would just say it looks good to me where it is. I think it's appropriate. It gives the parent the understanding of what they need to do, and I think it's appropriate where it is.
Okay. So,
I agree.
thank you, Mr. Mosier. Mr. Guarino and...
I agree. I don't think it's a big deal. I think where it is fine, and it's pretty much straightforward. I think people can understand it.
Okay. Ms. Hohensee?
When I read it, I start from the top. So the parents find something objectionable. The second paragraph is this human sexuality education. So that seems to limit the policy to that subject. In the event the parent finds some specific course material objectionable, it doesn't, at this point, there's confusion. Is that a broad, any course material, or are we now limited by that second paragraph? That's what's confusing to me. It's the placement.
And I don't disagree with you on that. That's why I thought perhaps putting, the board recognizes there's objectionable material occasionally. If you find a material objectionable, here's what you do. And then FYI, this one particular type of information we'll notify you about. And then here's what happens in either of those circumstances.
But we put headers like call one parental notification and then the other one, give it another header so that we know that they're two distinct things. Because right now they kind of blend and I don't think anybody will understand what's going on.
It was perfectly clear.
Yeah, Mrs. Oden.
I think Ms. O'Hensey is underestimating the intelligence of most of the people. I just think they will understand, reading this policy, exactly what it's talking about.
Thank you. Mr. Guarino.
I'd like to make a motion to accept policy IGE, and to accept it as presented and pass it to the board for full acceptance.
I'll second it.
Okay.
On the motion, Mr. Mosher,
Yes.
Ms. Raymond,
Yes.
Mr. Guarino votes yes. Motion carries 3-0.
Okay. So I just wanted to note that I'm continuing to go through the old policies. I'm trying to prioritize the oldest policies, the numbered policies. So expect to see more numbers next month as we keep going through this. I'm always open if people find things, as Mrs. Hohensee has, that are out of date, out of compliance with laws. Please feel free to send me an email, and I will incorporate it in an upcoming agenda. Some of the legal stuff, I'm not a lawyer. I like to ask for legal advice, so it might take a month or two, but that's the plan. Mrs. Fitzpatrick.
I just wanted to note that Ms. O'Gara gets the technical advisories, and I've spoken to her about forwarding them to me. So I'll be getting those now.
Excellent, because I very much want to make sure that we are getting ourselves up to date. Just so that people are aware, I've gone through this, and there's more things out of date than I can get done in the remainder of the calendar year. So it's a big project that I've given myself.
The technical advisories are also available on the department's website if you need to see any of them. They have quite a list.
Thank you, Mrs. Hohensee. So if there's nothing further, then I am looking for a motion to adjourn.
So moved.
Okay.
Second. On the motion to adjourn, Mr. Mosher,
Yes.
Ms. Raymond,
Yes.
Mr. Guarino votes yes. Motion carries 3-0. Thank you, Mr. Mosher.
You're welcome, sir.
Hope you're feeling better soon.